so I had no proof. So I asked a fellow employee who had witnessed the harassment to speak up, and they told me that even though they had been harassed themselves, they didn't want to say anything out of fear of rocking the boat. So even though they are required by law to investigate and take action against sexual predators, my employers were not willing to take the necessary steps to ensure a harassment-free workplace. In fact, they completely pushed me aside. I started to research how I could take action to hold them accountable and found out that I couldn't take any legal action due to an arbitration clause that I had signed. I had been forced to waive my rights, my legal rights to demand a safe and dignified workplace in the fine print of my employment contract. There was no way to make Burger King respect my rights, so I left my job. What else was I supposed to do? I was in the process of planning a wedding. I have a young daughter, she just turned 7, and I ended up being without an income for a couple months' time, and my soon-to-be husband Alex, he left the job with me because he did not want to work in a place that wouldn't take an issue like that so seriously. I know my story is not unique, and it sounds familiar to many people. I know I'm not the only woman or person that's experienced sexual harassment and felt like nobody listened when I tried to do something about it. This is why I am here today, to speak for everyone who has an experience similar to mine. Too many workers are kept quiet because of forced arbitration, and our voices deserve to be heard and not shut down by our employers. We need the opportunity to speak up when there is wrongdoing. LD 1693 will do just that. It'll make it possible for someone like me to take action when an employer is not cooperating. It'll give a voice to the voiceless. Thank you.
Hear, hear.
Thank you, Roxy. Our next speaker is Allison B.A. of the ACLU of Maine.
Good afternoon, Roxy. Thank you so much for your bravery and speaking out today. We definitely are listening to you. Thank you. My name is Allison B.A. I'm the Executive Director of the ACLU of Maine. We are here today to urge Maine's legislators to pass LD 1693 and restore access to justice for victims of workplace harassment and discrimination. Access to the courts has long been a crucial tool for holding companies accountable to the law and to the rights of their employees. 30 years ago, if an employee or a group of employees faced harassment or discrimination in the workplace, they could take their case to court. If a woman faced sexual harassment by her employer, or a group of black workers were treated differently than their white counterparts, they could sue. The lawsuit would have had the effect of bringing light to the abuse, deterring future discrimination, and achieving some justice for the workers. Today, the rise of forced arbitration agreements has largely done away with that. Today, if a worker or group of workers is the target of unlawful discrimination or harassment, they may not have the option to sue. Instead of bringing their complaint to court, they may have to bring it to an industry arbitration board made up of lawyers with no training on the legal issues surrounding harassment. The use of forced arbitration, in which employees knowingly or unknowingly sign away their right to sue their employers as a condition of employment, it slams the courthouse doors on victims of workplace harassment and discrimination. Arbitration lacks the procedural protections afforded by our justice system. Rather than going before a judge or a jury of one's peers, cases in arbitration are decided by panels of lawyers who are not required to follow legal precedent. And unlike court cases, these proceedings are subject to strict confidentiality. Even if a victim wants to discuss their case publicly, they can't. This secrecy thwarts public accountability for repeat harassers or the employers who have failed to stop them. As a result, too many valid sexual harassment and other discrimination cases never see the light of day. Repeat offenders are not held to account, and few survivors get true justice through this process. Yet despite this denial of justice, the use of forced arbitration has doubled in scope since the 1990s. And it is prevalent in female-dominated industries. 58% of female workers are subject to the practice, as well as in low-wage fields and industries dominated by women of color. To be sure, some people may prefer arbitration to the process of litigation, and they should have the right to pursue that course if that is their preference. But they should also have the right to pursue justice in the courts. To safeguard everyone's rights to be treated with dignity, Maine lawmakers should support efforts to protect all victims of discrimination. LD 1693 would preserve access to court for Maine workers when all other avenues have been closed off by corporations. Legislators should take this opportunity to pry the courthouse doors open again and ensure victims of harassment and discrimination get their day in court. Thank you.
Thank you all for coming today. Thank you to our speakers. We'll now take any questions.
Are you guys all set?
We're happy to arrange individual one-on-one interviews.
I'm all set here.